Willie was an IT consultant for the Federal Reserve Bank. One of his roles was to stay abreast of emerging issues regarding technology. Today, he's going to discuss the Internet and the First Amendment and try to clarify some of the confusion regarding mass media and constitutional rights. A heavy subject for us. Challenge us today. Willie's speech is entitled "The Internet Challenges the First Amendment." Let's welcome Willie.
Today we're going to talk about the Internet. We're going to talk about the First Amendment rights. And I'm going to try to give both sides of the issue. And we're going to have a little brief history on some of the key issues. In 1996, only 3 years after the Internet, the explosion of the Internet, President Clinton signed into law the Telecommunications Act. This is a massive piece of legislation, but we're going to focus on one component of it called the Communications Decency Act. Okay, now, what's also called the CDA. Now, the California Decency Act is important, although it has really, this happened in 1996, so it has since been overturned, but it's very important. And it's important because it's a landmark decision. It was the first effort to have content on the Internet legislated and controlled. That's why we're focusing on it. It was the first occurrence of legislation to control the Internet content. The CDA was initiated by Senator Exxon, a Democrat from Nebraska. He stood in front of Congress and he had a list of illicit websites and a list of illicit content. And he said, this is an example of what is available today free of charge. He's talking before the Senate. To give an idea, let me read through some of the listings. And he went on to read. Multimedia erotica, nude celebrities, erotic females, amateur females, erotica animals, erotica black males, erotica cartoons, gay men, erotica oriental, bondage, went on and on. Erotica hamster, erotica duct tape, erotica fury. I have no idea what erotica fury could be, but if anyone knows, let me know after the meeting. Opponents of this bill say that this is a throwback to the old Comstock law, which was discredited as an indecency standard long before the Internet. So why are we doing this again? But what is the Comstock law? Well, during the Civil War, there was a new technology that allowed obscene material to be distributed all over the United States. This new technology was called photography. And basically what was happening was wives, girlfriends, whoever, they were sending nude photographs of themselves to the soldiers at the front through U.S. mail. And so there was a postal obscenity law created to control this. It was passed by Congress in 1873. Well, Senator Exxon was just another Anthony Comstock. What Comstock did was he was called a special agent. He had the right to go into any post office, go through anyone's mail that he thought would contain obscene material. And what he did was he went before Congress with a sack full of stuff, dumped it on the table, and what he dumped on the table there was obscene material. There were abortion aids, there were aphrodisiac powders, and who knows what else, all gone through the U.S. mail. But as I stated earlier, this process was discredited long before the Internet. But people are saying this is just a modern day Comstock. Why go back to that? Let's look at the pro-decency side of the argument. Kathy Cleaver She was a past director of the legal issues for the Family Research Council. And she stated in an online magazine that the failure, I quote, the failure to enact strong laws is a concession that the information superhighway should belong to pornographers. It would be like leaving a loaded gun in the playground. In the book Applying Ethics, the authors quoted no less an authority than Aristotle. And he was quoted as saying, "It is our duty to see that our activities have the right character." Many ask the question, we monitor and restrict what goes on television and radio. We should extend those restrictions to the internet, and why not? Well, on the surface, that argument sounds like it's pretty valid. We do restrict content on the television. We don't allow anything on our open airwaves. Why can't we extend that to the internet? That's the question. That's the argument many pose. Let's look at the, what I call the pro-freedom side. And I quote, "Congress shall make no law abridging the freedom of speech or of the press or of the people peaceably to assemble and to petition the freedom of speech or of the press." U.S. Constitution, 1776. The magazine The New Republic explains the question of television and radio restrictions versus the First Amendment rights for the printed page. Remember, we do have restrictions on radio and television, but the printed page, there are no restrictions. Why is this? It is explained the following way. When the telegraph and telephone first emerged in the 19th century, it was regarded as forms of transportation. So the rights or the restrictions of the First Amendment had no validity. They were considered forms of transportation, like the railroad. They weren't considered vehicles of expression. So they were regulated without concern for the First Amendment. When radio and television began to flourish, judges allowed Congress to regulate them as public utilities. In granting the ACLU's appeal of the CDA, the judge concluded that the internet requires at least as much protection as a printed page, and this is why. It realizes the goals and the spirit of the First Amendment even more so than a printed page. What better place to get on the soapbox and state your opinion than the internet? In 1964, Supreme Court Justice Potter is quoted as saying that he could not define obscenity. But the famous quote is, "But I know it when I see it." If you look on the internet, yeah, I know it when I see it. There's pornography out there, no doubt. But you can also see medical procedures done with clinical detachment. That's anything but sexy. There's a ambiguity here. Pornography is intertwined with medical and scientific research. It's also intertwined with literature from great thinkers that themselves may have been censored at one time. As a nation, we've never succeeded in agreeing on which speech is good and which is bad. Because of this fact, the First Amendment does not make content-based distinctions. There are tools to guard your family from undesirable elements on the internet. There are tools. You can put restrictions on what comes into your home. So you do have that ability. The concept of free speech does not mean free speech for some. It means free speech for everybody. That's the general precept of our nation, free speech. Benjamin Franklin captures the bare essence of free speech when he said, "They that give up essential liberty to obtain a little temporary safety deserve neither liberty nor safety." Thank you.